The third panelist is Mr. Pablo Francisco Muñoz Díaz. Mr. Díaz currently serves as the Director General for Legal Affairs of Mexico's National Institute for Transparency, Access to Information, and Personal Data Protection. During his illustrious career, Mr. Díaz has served as advisor and Deputy Director General at the Supreme Court of Justice of the nation. A world-renowned legal expert, he has specialized in civil law as well. He is also recognized as an author and columnist.
Good morning. On behalf of the Mexican National Institute for Transparency, Access to Information on Personal Data, I would like to say thank you for the invitation and the opportunity to speak with you about the right to information in Mexico. First, let me explain to you that the right to information in Mexico is defined and is a constitutional right since 1977. But the first law of access to information is until 2002. And then we have also a constitutional reform in 2007, and the most recent reform of the Constitution is in 2013 that recognize and give density to the right of access to information. And I have to explain that the Mexican National Institute of Transparency, well, as we call it, INAI, has to guarantee two fundamental rights: the right to access to information and also the right to protection personal data. It is important to notice that merely the existence of a constitutional rule do not consider or recognize human rights not always means they are protected in reality. And first, we have to say that the Constitution recognized the INAI, the National Institute of Mexico, as an autonomous entity in order to have three important strengths. First of all, he has the autonomy of decisions that translates the freedom that the institute decides no matter what is in this competence. Also, the autonomy of operative says that attribution that is the institution elaborating freely his interior regulation and procedures. This is, he can free to decide how is the confirmation of the institute, and also he can has, as we call it, quasi-legislative powers, and we can do guidelines that are obliged to any public servant. And also we have budgetary autonomy, and this is most important because we can define how is going to be our budget, and we send our budget to the executive branch, and then the executive branch to the legislative branch, and that gives us enough autonomy. And the most important autonomy is that we can review, as according to the Mexican Constitution, all the information in custody of the executive, legislative, or judicial branch. Also, in the federal, local, or municipal authority, we can review any information that is in possession of the autonomous entity, public trust or funds, political parties, labor unions, and any person or company that receives public funding is considered public information. This is, we can review any kind of information. The most important thing here to regard is that we can review also the information of the judicial branches. It is, we can review the information, administrative information of the Supreme Court of Justice. The only exception that we have of reviewing the information of the Supreme Court of Justice is judicial files. But any information regarding administrative, how they expend the money, we can review it. And the most important thing, any resolution that the INAI established that has to open the information cannot be subject to any judicial review. This is, any authority must comply and must apply the resolutions of the INAI. This is a tremendous power for the institution and a lot of responsibility, because if we say that that information is going to be open, no one can contest it in any court. This is, no authority can go to any judicial court or any other instance to open information. But we have one exception. This is when some information of any authority is alleging that is for national security. This is the only exception that the Supreme Court will review the information, I would say, if it's the information regarding national security, could establish that we close. But if it's not, the information is going to be open. So we have to establish how we review the access to information. First of all, as Mrs. Kishaldi said, one principle of the access to information is that any person, regarding nationality, this cannot be a citizen, can access to information in Mexico. This is, you at this time you can go to your computer, you can ask information about our country. Anything information that is in possession of an authority, you can ask it. And also, you are not required to identify yourself. So if you want to say Mickey Mouse, you want to say Indiana Jones, you want to say everything, any character, any movie character, you can do it. And you never, ever, ever have to reveal your identification to the authorities. Even though if you go to court, because the only if you are denied information, if this is denied, doesn't think the information is going to be open, you as a person, a petitioner, can go to the court. Not the authorities, only the petitioners. So there are some principles in the general law that we can distinguish for elements. First, the obliged subjects that I just already told you, the judicial branch, executive branch, legislative branch, any public person, any person, private person, corporation that receives public funds, labor unions, every there are obliged subjects. And there are some governing principles of the right to access to information that you don't have to identify yourself. You don't have to have any power. You can access this information about your computer. You are not required to have an attorney in the proceedings. You can do it by yourself. And the most important thing that I want to repeat is you do not have to identify yourself. So if you're a reporter and you don't want any authorities think that you're asking for the information, you're not obliged to report to identify yourself. And this is a very, very, very important element, because if you are one of the strengths of the law, if you are most required to identify yourself when you're asking for information for the government, this could be an inhibited act. Let me explain to you. If you're required to say your name and you are asking for a very critical information for the government, and the government knows who are you, you can be seen, or you can feel inhibited to ask it because of any repercussion from the government. So the law, in Mexican law, does not require you to identify. So this is very, very important, because you can research any information, you can do general research, you can do any investigations for a note, and that will be benefit for the access information. Also, the law has a fundamental element, and it's called the national transparency system. In Mexico, we have a national transparency system that is construed up an organic set of members, procedures, instruments, and policies in order to strengthen the accountability of Mexico. It is necessary to mention that this system is contributed to efficient and effective federalism characterized by the commitment, by the transparency and the account surrenders to generation of quality information, to the management of the information and the processing of the same. Who constitute the national transparency system? There's, as a federation, we have 32 states, and every member of the 32 states have a representative of transparent commission or institute of transparency, and they constitute the national transparency system. Also, we have the national platform of transparency. What is the general law establishes the creation of an electronic platform that facilitates the access for information of implementing procedures. This is, you can access here in your computers, you have access to internet, you can access to the national platform of transparency, you can do your email account, or you cannot, and you can give your name or not, and you can ask information. At this time, you can make a petition to the INAI, the Institutional National Transparency in Mexico, and you can ask what I'm doing here, and I'm required to give you that information. The times in the general law is 20 days me to give you information, or I can ask for an extent of 10 days. and this will be in 30 days. You must have the information. If you are not happy with the information that I gave you, you can go to a review at the international National Institute, and we have 40 days to review the complaint, and we can extend it for 20 days more, and in 60 days you will have a decision. If you are not content with the decision, you as a petitioner can go to a judicial review at federal court or not. Well, what are the demands of the National Platform of Transparency? There are 4 main systems: system of request of information, the system of portals of obligations on transparency. That is very important because we have 2 mechanisms or 2 tools to give the people the information. This is, we guarantee the access information by acting, when a person does a petition does a petition to the authorities, or as according to the law, every person, every governed entity, it's obliged to upload some information that are construed in the law, and some in the National Platform of Transparency, and you must upload certain information, which is public contracts, the salaries, some contracts with the government. Everything goes in the National Platforms of Transparency. It goes in the systems of portals obligations. We also have a system of management of means of challenging. That is the appellate system, the appellate and the complaint systems we have in the national transparency systems, and also we have a system of communication between responsible organisms and obliged subjects. This is very important because the National Platform of Transparency makes what right to information, as we call it, a public service, and also as a public human right, because as a human right we cannot oblige to certain requirements for asking information. In Mexico we consider as a human right that you're not obliged to do to requirements of nationality or citizenship. So this is the most important thing of the National Platform of Transparency, because you at this time, as I already told you, if you want to ask information from Mexico, you can do it. Of course, there's going to be a problem with the language, but if you speak Spanish or you have a good translation, you can ask information of the government. And also, you can, if you are not, and the information you will receive the information also in the National Platform of Transparency. So, and the most important thing, if you are not happy with the information you receive, you can also put your complaint in the National Platform of Transparency, and every communication of that complaint will be received at the National Platform of Transparency. So, I think there are two very important things that we have to say about the general law in Mexico. As my colleagues established, there's some information that must be open, and there's some information with some requirements that could not be open. National security. But in Mexico, we have 2 exceptions about any reservation of information. This is any information that is related with several violations of human rights and acts of corruption cannot be, according to law, reserved. This is if the authority determines that some information is related with a severe violation of human rights, this information could not be reserved and must be open. And also, if the information is related to acts of corruption, it cannot be reserved, it must be open. There can be a denial of the information related to severe violations of human rights and also to acts of corruption. This is the strength, but this is the weakness. Even though we have those main principles in the law that acts of corruption and severe acts of human rights must be open, the problem here is that we don't have the law that defines acts of corruption and also the severe acts of human rights. So even though it's one of the most important strengths in the general law, and in several cases the national institutes had open information related to severe violation of human rights, there's also a problem with acts of corruption, because even though the Mexican National Transparency Institute is a member of this anti-corruption system, the anti-corruption system in Mexico, the main problem is they don't have a lot of laws that are defining acts of corruption and also some felonies of corruption. So that's a problem with the rights of access to information, because if we have stronger laws regarding anti-corruption violations, we can always open the information, and this will be a very important tool to fight corruption. But even though if we don't have the law, we're trying to establish some principles regarding some resolutions of the national institutions according to corruption, but it's a long way on. So thank you very much.